Welcome to Behind the Scenes. I'm your host, Hector Montalvo. This show is dedicated to asking tough questions for you, the viewers. We bring you their responses, and we let you decide. Joining us once again here at our MCTV studios, we welcome back Mr. Bob Norton. Mr. Norton, welcome back. Thank you for sticking around. In our last segment, we were talking about the conflict of interest within Senator Cream, within the judiciary, the laws, and so on. And we touched upon the child support. And that's been a very hot topic lately as well. Since we're talking about child support and lawyers and judges, I'd like to talk a little bit about the problems people face, families and children face within the family court system itself. Can you tell us some of the problems, including the child support issues, that you see people are facing?
Sure. Well, I mean, generally, these problems come from a lack of accountability and money-driven corruption. I'm going to call it corruption because that's what it is. When someone makes a decision for their own personal monies as opposed to their responsibility from their job, that's a form of corruption. Corruption isn't just paying people off. It's when they're violating their fiduciary duty to who they're paid to work for. So there's an enormous amount of that happening within our family court system today because the kind of Darwinian pressures that have evolved the system over the last several decades are mainly about money for the state and money for billable hours for lawyers, which is why we have the $78,000 average cost of a litigated divorce. It's just an outrageous amount of money, and there's no need for it. They have created an artificial maze for you to go through that isn't necessary because it's very profitable and creates a lot of billable hours to lead you through that maze. And most people, when they come out the other end of the divorce, they know they've been scammed. They know that their lawyer has billed them an enormous amount of money, but really provided no value. As we said in the last show, these lawyers are often sitting around for hours, sometimes double and triple billing the same client while waiting in the same courthouse. So not only are they billing $300 an hour for doing nothing for the client, they're potentially billing 2 or 3 clients at the same time for that hour of doing nothing. There isn't another industry in the world that operates like that. That's called fraud. Okay? It's pretending you're doing value to bill people when you're not doing anything for them. So the whole system is a racket in that sense. The judges are very complicit with this. I mean, all they would have to do to fix that problem is schedule what's called block time. You give people 2-hour windows, and instead of showing up at 9, waiting for the judge to come out at 9:30, sitting through everyone else's cases, and then maybe being heard at noon. They don't break to lunch till 1, so it typically goes to 1. That's 3 or 4 hours that cost thousands of dollars for people to sit around and do nothing. It's lost work, it's lost time, and it's a form of fraud on people because there isn't an industry in the world that does that. Even the cable company tells you, well, we'll be there between 2 and 4. They're a monopoly. This is a much worse than a monopoly. It's a monopoly and it's a cartel. And it's the lawyers that are legislators that are making the rules for the cartel. So we could do a 2-hour show on all the problems in the family court, and we can only hit them superficially. I would argue that there are a dozen different things that the Massachusetts Family Court does every day, a standard operating procedure, that are completely unlawful and unconstitutional. Some of the statutes have already been found in other states to be unconstitutional, and yet lawyers are still going on and enforcing these statutes that have been found unconstitutional already. For instance, child supports in Massachusetts continues after the age of 18 to the age of 23 if a child goes to college. Well, married parents don't have to support children after 18, yet the courts force divorced parents to do that. That's unconstitutional. It's what's called a bill of attainder, which sets up a group of people that are treated differently than everyone else. So a non-custodial parent and divorced parents in general are treated completely differently than married parents, and that in itself is unlawful and illegal. The child support system in Massachusetts is totally out of control. It was already the highest amount of child support, both in absolute dollars and percentage of income, in all 50 states prior to them raising it. The federal government requires you to go through a quadrennial, which is every 4-year review of that. They stuff the committee that does that with lawyers and judges who want child support to go up. This committee, Ned Holstein of Fathers and Families was on the committee, and this committee refused to look at the data around the cost of raising a child. So child support isn't child support. A better name for it would be child extortion, okay? Child support would have something to do with the actual cost of raising a child. Child support would include, it wouldn't include double and triple dipping. Child support would go to the child, not be able to be spent anyway by the parent. So, it would be complicated to go through the analysis, but let me give you, if you'd really analyze this, the USDA says the average cost of raising a child is about $118,000. So the proper way to figure child support, and not include luxuries in it, but just your basic costs, which, by the way, should only be forced on parents who abandon their children. If you want to take your child 50% of the time, there probably should be zero child support, because you're handling, obviously you can split 50-50, the medical bills and extraordinary expenses. You can do what you want for education and college. But the bottom line is, what they're doing is double and triple dipping with the child support calculations today. Child support today is about 39 to 40% of non-custodial parents' take-home pay. Hardly any parents in the country pay 40% of their take-home pay for one child. Okay, it's just, and there's check level number one that says the system's out of control. Okay, now what the parent does, it's about 26 to 28% of gross, but after taxes, since the non-custodial parent is paying all the taxes on that money, and the parent taking it, you've got to gross that up about 50% to adjust for about a 30% tax rate. So what we have is, if you have an average income in Massachusetts, which is about $60,000, household figure, you will wind up paying over the 23 years $356,000 in child support in Massachusetts, when we know the cost of raising a child for the basic necessities is $118,000. So a non-custodial parent is paying about 3 times what they should today in Massachusetts. The other way they're double dipping is they're including, that number would have to be adjusted, that 118,000, because 35% of that is the housing costs. Well, why should I be paying for my ex-wife's housing costs for the child and have to pay for a room for a child in my house? You've really got to back out that 35%. So when all is said and done, if you do this in a mathematical basis the way an accountant would, you come up with about each parent paying $50 per week per child for food, clothing, and the basic necessities. That's after tax numbers. That should really be a cap on what child support is today. Alimony is another scam. Essentially, alimony is sort of an obsolete concept. Alimony was created when women couldn't earn money. It's my belief, especially since the average marriage is now down to about 7 or 8 years before a divorce, that the parents should always go back to whatever they were doing before the marriage. Granted, there might be some transition period, but they're getting 50% of the assets. They're getting 50% of the retirement funds. They're often getting to keep the house, and of course, if you've got a single income family, it has to become a 2-income family, because now you're supporting 2 different houses. So this system is just insane. There isn't anyone but a lawyer that would set it up this way. Accountants that were meant to do this would come up with a cap of child support. This is essentially a kind of a socialist, communist income sharing scheme that has nothing to do with the cost of raising a child. I made a note of some of the other 10 things that the court is doing that are essentially blatantly unlawful. Every day is standard operating procedure, because they're profitable for the state and because they're profitable for the lawyers. The issuance of restraining orders, which we'll just spend a couple sentences on. These are being given out simply for saying the word fear, with no proof or evidence, okay? Now, you have the right to a jury trial if the government is going to take away any of your assets. They're dragging you out of your house. They're denying you access to your children. They're making you pay support to pay for that house you can't live in. Not only is there no jury trial, there's no real due process whatsoever. They've created a fake set of rules to do an end run around the Constitution to give these things out. Why? Because the Massachusetts government gets paid money by the federal government for every restraining order they issue. That's the impetus within the system to hand out as many of these as possible. These restraining orders destroy people's lives. They prevent them from getting jobs. They destroy their reputations. They deny them their children. They're a black cloud hanging over you if you go into a divorce with a restraining order on you. And all you have to do to get one issued in Massachusetts, if you're a woman at least, is say the word fear, okay? Fear is not due process, okay? You have the right to confront your accusers. You have a right to a jury. You have a right to present evidence against you. All of these things are totally eliminated in the process of granting restraining orders. The Massachusetts Appeals Court case law has done the right thing. All the judges I've seen completely ignore it. They say that to grant a restraining order, the defendant must have done something to make them believe or to cause serious physical harm, okay, which means breaking of bones, bruises, physical attacks. Well, they've kind of confused the word abuse with, rolling your eyes. I mean, a lot of domestic violence brochures out there say that rolling your eyes or sarcasm is abuse. Okay, so they've changed the word abuse, which is in the statute, to mean all these other things, which it was never meant to mean. But the DOR is acting as a third party in these cases with no standing.
Now, when you say a third party with no standing, our understanding, when we submitted questions to the Chief Administrative of Justice, Paula Carey, she responded that the Department of Revenue handles the Title D4 funding. Mm-hmm. But yet, when we go into the court system, we see them advocating or representing for one individual party.
Yeah, all they care about is collecting money, because they get a percentage of that money. It winds up being about $1 for every $3 in child support that is collected, that comes back. This is your federal tax dollars hard at work. The federal government is bribing the state governments with billions of dollars per year to separate children from their parents. That's the bottom line. That turns most people's stomach when they find out that that's happening, and it's very hidden. But the DOR, the Department of Revenue, is basically this big machine that comes down on people to generate these orders. They don't care if they're unemployed. They don't care if they're disabled. They don't care. I mean, I watched, you might have followed the Dan Iagata case years ago. They evicted a quadriplegic from his home, taking all the equity in the home he had inherited from his mother for legal fees. And the DOR is what's pushing these cases. So it's a nasty machine with no soul and no conscience that is blindly enforcing these laws. And it should not be involved at all in most cases, because it really doesn't have any standing in the case in the first place.
How does that affect a person that remarries? Let's say a woman remarries and her husband has a child. How is that particular person's assets and financial records come into play within DOR and the court system in general?
No, clearly a lot of the judges are asking for information of third parties as input into this. So if you're living with a new person, a new spouse, or unmarried or married, many of these judges are taking that person's income into account, which is inappropriate. It's a violation of privacy laws in the first place, because that new person doesn't have any standing in the case either, and so using their income is totally inappropriate. So there's all kinds of these things. It's when you create these financial incentives, people interpret the laws the way they want to get the maximum. I call this a corruptcy. I'm actually writing a book on this called Corruptcy, the Phenomenon That's Destroying America and What We Can Do About It. And it's a management science and leadership study of what's wrong with government. A corruptcy is a bureaucracy with so many layers. Each layer distorts further what the goal is at the top. And so by the time you go through 6 or 10, or in some cases 26 layers between the federal Congress and the local judge, it can be as many as 26 layers of people, and each one of those is doing what's ever best for them in their layer. So when a goal like child support goes in the top, what comes out the bottom after those 10, 15, 26 distortions has very little to do with the initial goal that might have been well-intended and good, but comes out as really an evil mechanism. It's blind and it's prosecuting people. As I said on your last show, I mean, I know people who have spent 6 months in prison because they had a heart attack and fell behind on child support.
Which is interesting, because you're absolutely right. I believe that the Constitution does say that you have the right to a jury trial for anything over $20, and you previously stated the same thing. But we hear that civil contempt and criminal contempt are two different things, yet in the family probate side of the court, we see nonviolent, non-custodial parents being thrown in jail for the simple fact of being broke. Is the incentive coming from the federal government to keep prison overcrowded?
Yes, there are monies. I'm not an expert in this, and I don't know the amount, but it costs about $40,000 a year to incarcerate someone in the Massachusetts, regular security prisons. So that's about $3,000-4,000 a month. They're throwing people in prison for being behind $1,000 or $2,000 for 6 months. So, let's maximize it and round it up a little bit. 4,000 times 6 months is $24,000 in taxes to pay for someone that's $1,000 or $2,000 behind in child support. Obviously no business in the world would do that, only government. There are funds that come from the federal government to pay for prisons. So I don't know what the percentage that the state pays versus the percentage that the federal government pays, but clearly people are looking at that as in the prison system and other government systems as a balancing factor. Again, the financial incentives that come from our federal government are perverted. They've caused more of the problem that those funds were designed to help with.
If this problem is affecting grandparents, it's affecting families, it's affecting children, it is driven by revenue, by money, what recourse do the people have? I mean, should they just sit back and allow their civil rights to be violated?
Right. Well, I think the first step is education. So it's great you're doing this show and getting the word out, because people don't realize how abused they are from the system. They're led through the system. The attorneys essentially lie to them and tell them things that aren't true. Oh, you'll never get equal custody, don't bother fighting. But the honest attorneys will say that and basically intimidate people into not being in their children's lives to save them the legal fees. The dishonest attorneys, they want 40% of your estate. And so they'll say, oh yeah, let's go fight for custody. They know damn well that there isn't a single judge in Massachusetts that will give joint custody right now without the parties agreeing to it. There may be exceptions, but I've heard judges have said that, and yet that's what the law is. The parents shall have equal rights. So that, in fact, is a statement of treason by the judges, because not only are they going against the Constitution and the rights of parents, they're going against the state statutes, and they're saying, I have no intention of obeying the law, I'm going to do what I want. So that's essentially activist judges, but they're doing it because it's become policy, because that generates the most money for government and for lawyers in the system.
Now, the U.S. Attorney General's office for the Commonwealth, in this case, is Martha Coakley. Her agency is in charge of overseeing all the corruption that's happening here. Why isn't Martha Coakley doing much more to protect the consumers and protect the interests of children?
Well, I mean, I don't want to try to answer that because I don't know Martha Coakley, but I think any attorney general, I think any sheriff, there are many cases that have happened where when these people are refusing to obey the Constitution as the superior law over the state statutes, they've been held liable. There was a case in in Vermont, where a judge was fined $250,000, and the sheriff that served the warrant went up to the Supreme Court, and the Supreme Court, Huminski was the case, that the person was putting a sign on his truck and going and advocating divorce reform at the Vermont courts. And the judge ordered the person to never be able to go into a court in Vermont. So that was denying them their right to not only grievances, but to court access. So the Supreme Court found the judge. When judges or any public official violates the Constitution, they immediately lose immunity. Now, most judges and lawyers, they won't tell you this, and they won't admit to it because it's their shield and their protection. But you immediately become what's called acting under color of law if you're violating someone's civil rights. You lose all the immunities that go along with being a judge, a police officer, or any government official whatsoever.
And if you're a judge, any order that you issued from there on after you violated somebody's due process or their constitutional rights, those orders are non and void, correct?
Yeah, they're considered. There's a difference, and this is a very technical point in the law, and in fact, I believe most lawyers don't even know it. There's a difference between what's called a void order and a voidable order, okay? Most people think they're the same. They're not. A void order is something that the U.S. Supreme Court says has the power of a blank piece of paper, as if it never existed. And you're right in pointing out, if a civil rights violation, including due process violations, happened in the issuance of that order, it's a void order. You don't need a court to say it's void, because you can prove it's void by whatever that violation was, by showing that happen. A voidable order is kind of more in a gray area, and you've got to get a court to say it's void because it's not as clear cut. But if there was a clear due process, it's called substantive due process, one that would have impacted the outcome, or a civil rights violation, that order is void, correct?
How does the court get jurisdiction over somebody?
Oh,
if you know.
You could probably spend a whole law school course on that one, and certainly I don't want to give anyone the impression I'm a lawyer.
Right.
I've gone to courses and I've studied this and I've learned it on my own, and I happen to be, a voracious reader. And I've read all the statutes around this, the U.S. Constitution, the Civil Rules of Procedure, and all the appropriate documents, but I'm not a lawyer. But there are some very technical and questionable points that I'm learning more about now myself, and others that are learning more about, especially around the 14th Amendment. The 14th Amendment created the administrative courts, and a lot of these courts, the district courts and the probate courts and others, are administrative courts. They're not judicial courts in the definition of the original Constitution. As a result, many people argue, and I'm not convinced and knowledgeable enough to state this as a fact, the way I do most of the stuff I know that I've verified from multiple sources. But what a lot of people are doing is becoming a state national and changing their citizen status from a U.S. citizen, which is a federal status created by the 14th Amendment, which was never ratified by the 50 states. And so many people would say the 14th Amendment really isn't in effect. So what they claim is that you can opt out of these administrative courts, and that a summons is simply an invitation. And if you walk into those courts and say the 14th Amendment wasn't ratified, I reject your jurisdiction, and I want a true judicial court, in theory, you can opt out of some of these things. There are many things that have been created in many statutes that are completely unconstitutional. We've been hanging up signs around the state, and there's a state statute that says you can't hang signs. Well, that's a violation of the First Amendment and free speech, and many other states have found that to be unconstitutional, yet judges in Massachusetts still find you guilty for a $100 ticket for hanging up a sign, and they don't even read the law. They refuse to read the law. That's an act of treason, okay? Because they're using the state statute over their oath to respect the Constitution as the superior law over any state statute. And there is case law that says any statute that is constitutional on its face, the judge should throw it out and dismiss it right away. That would be the proper thing to do.
And the effect, if you don't show up to court, that will result in a warrant being issued for your arrest. So technically, they would force you to make an appearance in the court system. So they're actually bringing you in and violating your due process and your constitutional rights if you decide to ignore the summons.
Absolutely. The people in the system are ignorant, and they're doing whatever the judges say. And that's because the checks and balances on the judges have been removed. I believe there ought to be limited terms for judges, and obviously there ought to be a mechanism. There's only 2 or 3 states in the country, New Hampshire, Massachusetts, and there might be a third, that elect judges, that appoint judges for a lifetime, okay? I believe the judges get worse each year they're on the bench. They get a God complex. They learn they can get away with more and more. No one is ever, it's like the mushroom treatment, we call it in business. You're covered in you-know-what and left in the dark. If you don't have negative feedback in a system, if you don't have accountability in a system, the people will over time get worse and worse and worse.
I can tell you that I have sent out numerous invitations to the probate family court systems, to the Department of Revenue. We've given them opportunities to come in and respond to our findings and to many complaints that we've looked into. They've declined those invitations, or some of our invitations have gone unresponded. But we have a minute left or so. Mr. Norton, if people needed to reach out to you, because there's a lot of family, especially in this tough economic times, people are hurting. Family are hurting. Schools are starting, and there are children out there that don't have their father or their mother to bring them to the bus stop or bring them to school. What do you tell those people that are about to go into the court system? How do they find courage to tell a judge, "You're not going to violate my rights"?
Well, the first thing to do is try not to be in the system at all. I mean, you can do an uncontested divorce. There's a box you check when you're filing a divorce complaint, whether it's contested or uncontested. If you can work everything out outside of the court system, that's purely 100% better way to go, if not 1,000% better way to go. Work it out with your spouse directly, everything you can. Take what's left over and maybe get a mediator that is not a lawyer. Okay? Lawyers are trained in conflict and inherently create conflict by using the rules of their system. Mediators will have the exact opposite way. The number 1 rule in mediation is keep a line of communications open between the parties so that things can be resolved. What's the first thing your lawyer will tell you? Don't talk to the other side without me. They want to control the case. They want to cut off communications. So as soon as you start to get involved with the system, it's going to lead you down a path of destruction, because that's what the system is designed to do, to generate money for lawyers and for the state. And that's their number 1 priority. It's a conflict of interest. It's a self-interest overriding the best interest of their clients and the people. And most people don't even know it, but a lawyer's duty is to the court above their client.
Thank you. Well, it was interesting having you on the show today. Real quickly, if you can just briefly, your website real quick.
Contact information, the website is www.fathersunite.org or divorceracket.org. Takes you to the same website. There's lots of statistics. There's lots of help and documents for people, information, stories, and other resources. There's also info@divorceracket.org is an email address. And we do try to help people. We try not to get involved in individual cases. We're not lawyers, but we do try to give people information under the First Amendment.
And real quick, you're going to be in Newton Center, I believe, this Saturday.